Development Fund Act of 2015 has been declared unconstitutional by the High Court. Now, three-judge bench comprising Justice Mugure Thande, Justice Kanyi Kimondo, and Lady Justice Roselyne Aburili ruled that the act violated several constitutional principles, including the separation of powers and Chapter 12 of the Constitution, which outlines the principles and framework of public finance. Now, the court also found the passage of the act unconstitutional because it only involved the National Assembly, despite the matter also affecting counties, which required Senate's involvement. However, the act's invalidity has been extended until midnight on June 30th, 2026, due to ongoing projects. Well, so far, 15 judges have ruled the act unconstitutional.
Members of the National Assembly, senators, county women representatives, and members of county assemblies ought not to be involved in the implementation of any service-based mandates which are a preserve of the executive branch. This is the only way to respect the constitutional scheme on separation of powers and ensure that the legislator's oversight mandate is not compromised through conflict of interest. Tolerating a contrary position would harm the Constitution's value system, particularly the national values and principles of accountable and good governance. End of quote. Thus, as long as the fund, as established, involves aspects of service delivery, however well intended, has the effect of creating structures that are incompatible with the nature of the distribution of functions between the two levels of government.
Constituency is not a unit of service delivery, and have found for this and other reasons that the impugned act and fund are unconstitutional. The time is now ripe for the people of Kenya to appreciate that a constituency is not a service delivery unit, but a unit of representation, and that the role of the member of the National Assembly must remain that of representation.
Unit for development offends the basic structure of the Constitution. The reply by the first respondent is that the basic structure doctrine is not applicable in Kenya, and reliance was made to the Supreme Court decision in Attorney General and two others versus Day and 79 others, where it was stated, and I quote, "The basic structure doctrine and the four sequential steps for amendments as prescribed by the High Court and the majority of the Court of Appeal were not applicable in Kenya."
Now,